Good morning and welcome to another of our coffee break webinars. For those of you who may not have tuned in before, my name is Elaine Brailsford and I'm joined by Stephanie Hepburn. We're both members of Shepherd and Wedderburn's Rural Dispute Team. So, possession is 9/10 of the law, so they say. But is it? Today we're going to talk about acquiring title to land through possession. The basic premise is that if a person possesses heritable property for 10 years and does so as an owner, so not as if they were a lessee paying rent, etc., then that person would, at the end of the 10-year prescriptive period, acquire an unchallengeable title. But perhaps that only is 9/10 of the law, because if, say, Stephanie here possesses land for 10 years, that on its own is not enough. One fundamental requirement is that Stephanie must have an ostensible registered or recorded title. Of course, if she had a good title, then she wouldn't need to rely on prescriptive possession. Ownership by prescription is where the underlying title is ex facie valid, but in fact is not valid, or indeed it could be voidable. And there are two scenarios where ownership by possession commonly occurs. Firstly, where the land is ownerless, and secondly, where someone acquires title to an area of land in error, but this error is in good faith, and they then enter into possession of that area. And we'll briefly cover both of these this morning.
There was an interesting reported case in this area earlier this year. Back in 1994, Mr and Mrs McGregor disposed an area of land at Glenborrell. It was around 5,000 square yards, and they sold it to themselves, i.e. they signed the disposition from themselves to themselves, and for the next 20 years they occupied the area of land. So after 20 years, I'm thinking the McGregors probably thought they were home and dry. But in 2018, the Ardnamurchan estate commenced proceedings against them in Fort William Sheriff Court. And the estate was looking for a decree for the production and reduction of the 1994 disposition, and for declarative that Mr and Mrs McGregor were not in fact the heritable proprietors, and indeed had no interest in the subjects. And the estate sought a declarator they in fact were the true owners of the land. And the matter at issue was whether or not there was an underlying ex facie valid title. The sheriff at first instance found for the McGregors and held the 1994 disposition was not ex facie invalid, and the estate appealed. The question before the court was whether or not a disposition in favour of yourself was a fundamental nullity. There wasn't a dispute that a person can't enter into a contract with himself, but the McGregors argued there were exceptions to the rule. So, for example, a party could contract with themselves if wearing different hats. So Elaine could, for instance, wearing her trustee hat, contract with herself as an individual. The McGregors argued they didn't have to actually state whether or not any of the exceptions applied in the case or not. I think it's hard to say that they would, but they said the mere fact there were exceptions meant on the face of it, the deed could not be said to be said to be ex facie invalid. The appeal court wasn't very impressed with that argument. They described it as a curious proposition and found against the McGregors. So as a result, it's clear that a disposition from one party to himself is invalid on the face of it and can't be the foundation to a prescriptive period of possession. So Elaine, just how do you acquire a right of prescriptive possession to land where the true owner can't be found?
Well, it's perfectly possible for another person to grant you the right to an area of land, even though they don't own it. In theory, I could grant a disposition over an area of land to you, Stephanie, even though I don't have title to it. And the granting of this right is what's known in Scots law as a non domino disposition. Now, we're awfully keen on our Latin phrases. We keep throwing them out there.
Elaine, I'm not so keen.
But anyway, what it means is ownerless. So it's not just as simple, though, as me granting you, Stephanie, a disposition of some apparently ownerless piece of land and for you to then possess it for 10 years. There are a number of steps which must be followed. And the first step is before the keeper will accept my disposition in favour of Stephanie, Stephanie must already have possessed the land for at least 1 year. Now, this is not to be confused with the 10-year prescriptive period. This is more like an entry qualification, if I can put it like that. Secondly, the person who appears to be the true owner must be notified. Stephanie might expect parties to appear out of nowhere at this stage, claiming their right to land, even though, until they've received notification, they probably had no idea that they might have had title. The purpose behind notification is really to satisfy the keeper that you've taken steps to identify the true owners and you've attempted to contact them. And this ensures that purely speculative applications are not accepted. Otherwise, it could be completely open to abuse. I could, without telling anyone, have my friend dispone to me a bit of the field opposite, and I'll camp out there for 10 years. No, that won't do. I shouldn't be able to do that. So notification will be made to the proprietor if you can identify someone. And if there's no proprietor or you can't identify them, then you should notify any person who appears to be able to take steps to complete title.
So that could perhaps be a success if there's been a death. I guess, though, if there's no such person, you must notify the Crown.
Yes, and the keeper is going to want to see evidence of what you've done to identify the proprietor. And that may involve providing evidence as to whether the person identified is still capable of being a proprietor. Are they still alive? If it's a company, have they been dissolved? So the keeper also actually has to do her own notification. And this is essentially to protect against any fraud. And if you're unlucky enough to have somebody who has been notified object, then I'm afraid that will be the end of the matter. The keeper is not required to assess the basis of the objection. And this is because the person objecting has already been identified as the appropriate person to notify in the first place. And that person's not required to give any reasons for their objection. So if that's not all difficult enough, Steph, you'll be faced with the one-shot rule. And that means that the application presented needs to be right first time, or else it will face rejection.
So, assuming you've got all your evidence together, you've possessed for 1 year, notified all potential proprietors, and there's no objections, what happens then?
Well, where the keeper accepts the application, known as a prescriptive claimant application, she will mark the resulting entry in the title sheet as provisional. And the rights which you, if it's you, Stephanie, will acquire will be provisional until the 10-year prescriptive period has run to validate them, provided, of course, that there's sufficient possession to meet the terms of the Prescription and Limitation Scotland Act 1973. The 10-year period is calculated either from the beginning of possession or registration of the deed, whichever is the later. So if your 1 year qualification, you've had to have your 1 year qualification, that won't count towards your 10-year prescriptive possession. The possession must be open, peaceable, and without any judicial interruption. So, Steph, if you take possession by force, that won't count. Mm. If you possess the land for 9 years, and I come along and raise an action to recover possession of what I claim is my property, then your possession will have been judicially interrupted. And if my case takes 2 years to conclude, taking us into year 11, and I'm successful, you will not have acquired ownership, even though you may have been in possession for 10 years.
So what Elaine's just discussed then is all about ownerless land, or land where the true owner can't easily be identified. But what about the situation where, say I purchase a field, it's on the land register, I've been occupying the entire red line boundary of the registered title, including a paddock at the back of the field. Someone comes along and says, hold on, wait a minute, I own that paddock, and therefore trying to establish that my title is inaccurate. And in that case, my title may be open to rectification. So looking at where rectification may be possible, the first thing we have to look at is whether your title was registered under the older Land Registration Scotland Act 1979 or the newer Land Registration etc. Scotland Act 2012. The 1979 Act rules didn't just disappear when the 2012 Act came into force on 8th December 2014. So under the 1979 Act rules, unless very limited exclusions apply, and the most common one is fraud, the keeper will not rectify someone's title if that rectification would prejudice a proprietor in possession. And that's commonly known as the keeper's Midas touch. Once your title is on the land register and you enter into possession, it turns to gold. Mm-hmm. Even if your title is clearly wrong and it should never have been transferred to you, if you're in possession, it's very, very hard to challenge that under the 1979 Act. So looking at my paddock example, if it's a 1979 Act title, to prevent a challenge, you must have your underlying legal title upon which my possession is based, so a deed or a disposition, for example. And importantly, I must also be physically possessing the paddock, and possession depends on the facts and circumstances of the case. It's not defined in the 1979 Act what possession actually is, and there's been a number of cases setting out what sorts of evidence will be required to establish the possession. There's a presumption in favour of possession, and the onus is on the party seeking rectification to rebut that. Things like erecting fences and signs, planting trees, shrubs, mowing the lawn, perhaps building on the land, or allowing animals to graze on the land are all examples which may evidence possession. It's clear, though, that what's required to possess, say, a back garden attached to a house in an urban setting is going to be different to what is required to possess moorland in a remote area of the Scottish Highlands. So if my title to the paddock is a 1979 Act title and I can demonstrate possession, it's very unlikely the true owner would get the paddock back, but he may be entitled to compensation from the keeper.
And what if your title is registered under the 2012 Act?
Well, things all changed when the 2012 Act came in, and the 2012 Act favours the true owner of the land in question, and the keeper's Midas touch no longer applies. Under Section 80 of the 2012 Act, the keeper must rectify a manifest inaccuracy in the title sheet. And under Section 65, the title sheet is manifestly inaccurate insofar as it misstates or wrongly depicts or shows what the position is in law or in fact. The inaccuracy must be clear and not reasonably disputable. It shouldn't be in doubt, and an inaccuracy will be manifest if it's been judicially determined. For 2012 Act titles, so that's those where an error existed on or after 8th December 2014, possession doesn't matter, and the person who is entitled to the land, insofar as property law is concerned, should win. But what about 10-year prescriptive possession? Elaine, can you tell us more about how this sits with rectification?
The first thing to say is that prescription doesn't run on a 1979 Act title unless the keeper has excluded indemnity. There are only two situations where prescription is important for rectification under the 2012 Act. The first is where the title sheet is marked as provisional because an anno domino disposition has been registered, as I mentioned earlier. And in that case, where evidence of 10 years possession is produced, the provisional marking will be removed from the title sheet, and it's no longer vulnerable to rectification. And the second situation is where there's a manifest inaccuracy in the land register, and that manifest inaccuracy is not rectified, and the land is sold on to a third party acting in good faith. Now, provided the good faith purchaser possesses for 1 year, there can be no rectification. Likewise, if a manifest inaccuracy is produced by the keeper in a title sheet, and the land is possessed for 10 years, openly, peaceably, and without judicial interruption, rectification will not be possible. And this is called a realignment of rights.
All sounds a bit complicated.
It is.
So if a land registered title has not been registered for more than 1 year, then it's possible the title may be rectified if there's a manifest inaccuracy and the true owner applies for rectification within the first year.
Yes, that's right.
And if a land registered title which contained a manifest inaccuracy at the time of its first registration from Sazine to land register, that is vulnerable to rectification by the true owner for up to 10 years from the date of registration if there's not a subsequent sale by the first registered owner.
Yes, that's correct. If we go back to your example, Stephanie, of the paddock, if you haven't yet purchased the paddock and it's still on the Saysine register, then you'll need to check whether the underlying Saysine title is habile to include the paddock. And if it's not, and the true owner cannot be identified, then you'll need to go down the prescriptive claimant's anno domino route and wait 10 years and satisfy the prescriptive test before you're home and dry.
Okay.
If the paddock is still on the Saysine register and the true owner can be identified, then you cannot acquire title to that paddock. And this would be misleading the keeper. Prescription isn't relevant. As I mentioned earlier, you cannot just choose a bit of land that you like the look of and camp out for 10 years to acquire a good title. If the title to the paddock was already on the land register when you purchased and you acquired title, then, and you were in good faith and you possessed it for 1 year, your title to the paddock cannot be rectified, notwithstanding that the land register may be manifestly inaccurate.
Okay, all very complicated.
All very complicated, no doubt as clear as mud. Please contact us, email in your queries. You've probably got loads. Next week, Hamish Lean's up speaking about problems with diversification on tenanted holdings. But for now, thank you for tuning in and good morning.